our motion really has two purposes, but both based within the specific context of this case. So we're not seeking just in general to say people in unions, you should consider their testimony differently. It's the context of this case, Your Honor. And if our motion was not specific in that regard, I apologize, and I'll try to add that precision now. The specific context here is a union that provides services and defense for its members when they are questioned about their job performance. And those are very serious matters. They're often very serious matters, as we know. And so that sort of defense, that assistance, is a little bit different than a lot of unions. This case is about an officer's conduct, and so in the sense that when people worked with Ms. Potter, they felt that as their union rep or president, she had their back. The question is whether witnesses that are still a part of that union or were a part of that union when they knew her might feel like they should have her back. I'm not saying that's true. I'm saying that's a question that the jury should decide based on that evidence. So that's one purpose for that. Not to cast aspersions, of course, on unions or anybody in particular, but it is part of the relationship of those two parties that is tied to the allegations in this case. The second basis upon which this motion is brought relates to a specific witness who we expect to testify, who is currently, as we understand it, working for that union that provides defense. And so we certainly, if that's true, intend to ask him about that, because it would be no different than the defense hiring an investigator to come in and testify to facts. We would put in that they are paid to do that. And so if that witness is going to testify about the conduct, we think we have a right to inquire about that relationship as well. So those are the limited bases upon which we sought to admit that evidence and submit that it is relevant to the issues at hand for the jury's consideration. If they assign it no weight, that's their prerogative.
Okay, here's the problem that I see, and I'll let the defense respond as well, but Officer Potter, former Officer Potter, is no longer connected to the police union in any way. So witnesses that are testifying couldn't possibly be biased to testify in her favor because of her position.
I think the point is that over the years, there was a relationship between Officer Potter and other witnesses who were in the same union that had the same interests. And as I said, it's not just that they worked with her, it's that she had this additional role in defending them and providing services to them. In that sense, they were more than just co-workers. It's a stronger potential bond, and that should be something the jury gets to know about when they're considering the relationship of the witness and the party.
Okay, Mr. Ng.
Well, the evidence is that former Officer Potter was the union rep for 2 years. What is critical here is that they're attempting to show a relationship that doesn't exist. Tim Gannon, the chief, was not in the union whatsoever. Sergeant Johnson wasn't in the union. Acting Chief Grinning wasn't in the union. So there's really no connection. And her role was essentially to negotiate a labor contract, pay and leave and that sort of thing. And it was quite limited. It's not like the Minneapolis police where there's a very powerful union rep that we've read about, for example. So there's no showing of bias, and the individuals they're concerned about weren't in the same union anyway.
Okay. Did you want to respond? Yes, you.
Just 2 quick points, Your Honor. Officer Johnson would have been a member of the union until, I think, 2015 when he became a sergeant. And Tim Gannon is currently employed by that union. And he will, as has been represented to us, will come in and offer opinions, thoughts, and so we think it absolutely relevant that he is now employed by the union that also employs legal defense for officers.
All right, I'm going to find that the questions about union membership and Officer Potter's former activities in connection with the union are not relevant to show bias. So I am denying the motion of the state. The second motion the state has is to preclude quote, improper lay opinion testimony. And would you like to briefly be heard on that, counsel?
Yes, Your Honor. Thank you.
Thank you.
Your Honor, the defense had disclosed 2 expert witnesses in this matter, Dr. Miller, the psychologist, with respect to their theory on slip and capture, and Mr. Iams with respect to use of force. What they have done since those disclosures is essentially try to turn other cops into expert witnesses. The court heard from Sergeant Johnson on Friday. Sergeant Johnson testified to issues with respect to use of deadly force, application of a statute, things that are particular legal conclusions that are outside the scope and improper lay opinion. The parties had discussed this with the court sort of beforehand in chambers. It was an issue that we raised. The way that this went down on Friday was extremely prejudicial, but also extremely improper when it comes to the way that lay opinions might be used under 701. Under Rule 701, a lay witness may offer lay opinion testimony on issues that are sort of common everyday occurrences. That does not include things like legal conclusions, things that require particularized or specialized knowledge. They don't, of course, encompass things that are ultimate issues for the jury to decide, including whether or not deadly force is reasonable, whether or not any particular force that was used was reasonable in this case. Those are issues for the jury. Those are issues that are central to this case, not proper for lay witness testimony. Because of the testimony that was heard on Friday, of course, the state has now asked that the court prohibit any further inquiry along those lines and ask the jury to disregard those specific opinions that were outside the scope of any lay witness. The concern as well is that the defense has also provided some disclosures with respect to their anticipated witnesses. That includes former Chief Tim Gannon. It appears that he may also offer similar opinions with respect to whether or not the use of a taser was reasonable, whether or not the use of force was reasonable, his review of video having not been a part of that interaction whatsoever. And it also appears from their disclosures that he may ultimately try to offer opinion with respect to their slip and capture theory, which again would be improper. Whether or not she experienced any phenomenon, that would be what they're trying to describe as a slip and capture. Your Honor, obviously if we had known that this was where they were going and these questions were coming out to that extent on Friday, it's something we would have raised again in the moment, but of course we are now in a position where they have blown open this door. This was not a question just about what happened on that day and what did you see and what did you do. There were questions about, does this statute apply? When does this statute apply? All of those call for legal conclusions. All of that is improper lay testimony, Your Honor. So we have concerns about what has been done. We'd ask for an instruction that the jury be told to disregard those types of opinions, but we also want to make sure that those are properly limited going forward with respect to the witnesses they intend to call. Thank you, Your Honor.
Your Honor, we object to that motion. We ask that it be denied. It was their witness. I cross-examined the witness. I did not ask about any statute. He's the one that brought up the statute. If they didn't prepare the witness correctly, that's their problem. In addition to that, they never objected at the time. So now they want to redo the testimony that the jury's already heard. It's actually proper lay testimony as far as a witness goes, because his perception is there. He was in the vehicle. He said he was, and he has that's a rationally based perception under Rule 701. Helpful to clear the understanding of the witness's testimony or the determination of the fact and issue. Well, he sure was helpful. He was there, and he gave his opinion as to what Kim Potter did was reasonable. And that's a lay opinion. And it's not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. I'm reading from Rule 701, Your Honor. It's proper evidence. We did not have to give them notice, oh, by the way, we're going to cross-examine your witness with these issues. They should have known that, since he's given statements. I didn't pull this out of the clouds. They had taken statements from him that say these things. So we adamantly object. They didn't object last week, and now they want to redo the trial. Thank you.
Okay, Ms. Aldridge.
Thank you, Your Honor. If I may respond briefly to that. When it comes to Rule 701, 701 is a rule that allows for lay witness opinion on matters for which they have personal knowledge. So things like, what did you see? Was the car speeding by as it went by? Things like that. In this case, what the defense has done is asked Sergeant Johnson on Friday, and presumably will ask additional witnesses, to assume and speculate what was in the mind and known to Officer Potter, former Officer Potter, at the time these decisions were made. That is not a personal opinion. That is definitely not a lay opinion, and it's outside the scope of that rule, Your Honor.
All right. Anything further?
Well, Your Honor, they didn't object. I cross-examined the witness. There was no objection at all. There wasn't anything last week.
Okay, first of all, Officer Johnson's opinion, I am not going to tell the jury to disregard. When that issue came up, I ruled that police officers can testify about what they have been trained to do under certain circumstances. There appear, the defense, I think the state's motion goes beyond Officer Johnson. They're also trying to preclude any of the police officers that will be testifying in this case from issuing or eliciting opinions concerning whether or not the use of the taser was appropriate under the circumstances. And I believe that the police officers, due to their training, are entitled to render an opinion on that. And it's totally appropriate for them to do that. So, I don't know if there were other areas that the state had a problem with respect to expected police officer testimony or not.
Your Honor, we did. It was not just whether or not the taser was appropriate, but there were opinions about whether deadly force would have been appropriate, and also with respect to the psychological components of whether someone would experience things similar to slip and catch.
Okay. There is no question that no witness, including the defense expert witness, can testify that Officer Potter experienced action error or slip and capture. Nobody can say that. But I'm not going to preclude any of the officers from testifying that based upon their training and experience, deadly force or use of taser was appropriate under the circumstances. Okay. Is our counsel ready for the jury?
Judge, may I be excused from that? I forgot my water.
Yes, you may.
Thank you.
Okay, thank you, Deputy. Will you members of the jury please be seated? All right, the state may call its next witness.
The state would call Commander Garrett Fleslin to the stand.
All right, officer. Please stand behind the witness chair and raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in connection with this matter?
I do.
Have a seat. You may remove your mask. State your full name and spell it.
Garrett Flesland, Garrett
Okay, officer, a couple things to keep in mind. The court reporter is taking down everything that is being said. You have to answer with a yes or a no. Don't shake your head. Don't say uh-huh or uh-uh. Don't talk at the same time as the lawyer asking the question. If an objection is made, stop talking immediately. Don't answer unless I tell you to. And if you need clarification on the question, let the lawyer know. All right? Counsel?
Thank you, Your Honor. Good morning. Can you tell the jurors what your current occupation is?
I'm a police officer for the City of Brooklyn Center.
And what is your current position there?
I'm one of the commanders within the department.
So are you a licensed peace officer in the state of Minnesota?
Yes, sir, I am.
How long have you been licensed?
21 years.
When you Well, just tell the jurors what year it was so we don't have to do the math.
I was licensed in August of 2000.
And when you're licensed, do you have to meet certain requirements in order to get that license?
Yes, sir.
And after getting it, do you have to do certain things to keep it?
Yes, sir.
Does that include training, education, etc.?
A variety of training requirements and continuing education requirements.
And since you got your license, have you done all that was required to maintain your license?
Yes, sir, I have.
But just go into your background a little bit more, if that's all right. Tell the jurors where you went to high school.
Park Center High School in Brooklyn Park.
And after high school, what did you do?
I enlisted in the Navy.
And which, well, let me ask this. How long were you in the Navy?
Total, just about 10 years between active duty as well as I was picked up for an ROTC scholarship. So I went to college in the middle of that.
And so how many years of active duty?
Just under 6 years.
So when in the 10 did you start the educational or the ROTC component?
I enlisted right after high school in the nuclear power program. After a little over a year, I was selected for ROTC, and that's when I went to college. And then after college and commissioning, then I went back for about 5.5 years of active duty.
So when you went to the college there, did you get a degree?
I did.
What was the degree in?
A Bachelor of Science in Physics.
Was that relevant to your work in the Navy?
Yes.
And so at some point then, when you got out of the Navy, did you have to make a kind of a career choice then?
I did.
What choice did you make?
I decided to pursue law enforcement.
Why?
Grew up with a value in service to others. Felt like it would be a good way to continue to serve the community. Family members are in law enforcement. It seemed like a noble profession to continue.
And not any names or anything like that, but like, how are your family members in law enforcement related to you?
My father was a police officer. My wife is a police officer.
And so how did you then go about pursuing a career in law enforcement?
The state of Minnesota has requirements before you can get licensed as a peace officer. One of the requirements that a lot of people pursue is a 2-year degree in law enforcement or criminal justice. I did not have that. I had a 4-year degree in something other than that. So I needed to obtain a law enforcement certificate. So I went to Alexandria Technical College for roughly 8 months of classes and skills, and that satisfied the post requirement as far as the educational aspect to be eligible for licensing.
And so it was a 2-year degree?
No, that was just a certificate.
Okay. And then do you also have to do like a skills component?
Yes.
Explain that for the jury, would you please?
The program I went through was called the Career Transition. It was for people that had a 4-year degree in something other than law enforcement. It was 1 semester of classes that knocked out a lot of the juvenile law, criminal code, the academics. And then there was a skills portion. I believe it was a 10-week. It was either 8 or 10-week portion, and that's where you do more of the physical aspects of it, learning defensive tactics, handcuffing, there's a driving component, firearms, a variety of more hands-on sort of activities.
Kind of just as it sounds, the skills you need to be a police officer.
Yes, sir.
And did you then, after achieving those things, apply for a job?
I did.
Where did you apply?
I applied several places. One of them was City of Brooklyn Center.
And you got hired there?
Yes, sir.
And that was August of 2000?
Yes, sir.
And what was your first role or position with Brooklyn Center?
I was a patrol officer.
And so out on the streets?
Yes, sir.
What are your duties as a patrol officer, or what were they?
They can be varied, but essentially you're responding to 911 calls for service when people call the police looking for help. When you're not doing that, you're proactively enforcing traffic, interacting with the community and the public, the traditional things you think of when you think of a uniformed officer on the street.
So when you took the job with Brooklyn Center, was it sort of a coming home for you, where you grew up?
More or less. I grew up in Brooklyn Park. right next to Brooklyn Center. I grew up in that community.
And so when you're out there on the streets and doing patrol, are you making arrests,
Yes.
writing reports,
Yes.
experience with, well, I'll back up. Did you go through a field training officer portion of your work there?
I did.
How long was the field training officer program when you went through it?
Between 3 and 4 months, probably closer to 4 months.
Are you familiar with the current field training officer program at Brooklyn Center?
I am.
Are they relatively similar?
Very similar.
So you started in 2000. Do you remember the date that you were sworn in?
August 29th of 2000.
And why do you remember that?
It's a significant date. It's when I started this career.
When you're out on, you get your patrol assignment. At some point, you get a promotion to a different position.
Yes.
And when was that?
The first one was in January of 2004. I was promoted to detective.
So as a detective, what did you do?
Investigated cases. A lot of times you take a case that was initiated or initially investigated by a patrol officer, and you continue to see it through as far as gathering evidence, eventually potentially presented it to a prosecuting attorney for review and charging.
And how long did you do that?
A little over 6 years.
Do you specialize in any kind of cases or just whatever call comes in?
No, we were considered general detectives.
And after that, you said that 6 years, did you receive a promotion then?
Yes, sir.
And what was that promotion?
I was promoted to sergeant.
And can you describe for the jurors, we've heard patrol and sergeant, detective, kind of what the hierarchy is within the Brooklyn Center Police Department?
We've got a chief of police. When we're fully staffed, then we've got 3 commanders and 1 support service manager. The support service manager is a non-sworn position. He or she oversees records and other aspects of just conducting day-to-day business within a department. But then the 3 commanders each oversee a different division. 1 oversees patrol, 1 oversees investigations, and 1 oversees community services.
And so going from detective to sergeant was a promotion sort of in rank?
Yes.
And which area were you the sergeant of?
As a sergeant, I was a patrol sergeant. I was assigned a shift of officers. Throughout most of my tenure as a patrol sergeant, I worked nights, 5:30 at night till 5:30 in the morning. I'd be charged with overseeing and supervising this group of officers as they would go handle 911 calls. They would proactive details, basically carrying out policing throughout the city.
While you were a sergeant, did you pursue some additional education?
I did.
And can you describe that for the jurors, please?
I obtained my master's in police leadership from the University of St. Thomas.
And what year did you achieve that?
2013.
And how was that sort of helpful to your job with Brooklyn Center?
It was a pretty broad program that covered a lot of aspects of police leadership, best practices throughout policing. In some respects, it solidified some of the things that I had learned and discovered over my years, and as well as introduced me to new concepts.
At some point then, did you get another promotion?
Yes, sir.
And when was that?
September of 2015.
What was that promotion?
I was promoted to commander.
And that's where you currently are, your current position?
Yes, sir.
So when you first got promoted, what were your duties as a commander?
I was assigned to patrol, so I was the patrol commander. So I oversaw that position, or that division, which typically consists of 6 patrol sergeants, 26 patrol officers, between 8 and 10 cadets or community service officers, non-sworn positions.
And do you know Kim Potter?
I do.
And how did you get to know Kim Potter?
We were co-workers. She was employed at the police department when I was hired,
How long have you known her?
since I started working in 2000.
And were there times when you would have been then her supervisor?
There's a few brief periods where I was her sergeant.
Explain why. Or when those periods were, trying to understand why you would have been brief periods as her supervisor.
We end up juggling responsibilities and roles sometimes as people leave. She was a day watch officer for most of the time that I was there. She had a different day watch sergeant. When he retired, we shuffled positions a little bit, and I was the day watch sergeant for a brief period.
So really just as schedules or shifts went.
Yes.
Turning your attention to the investigation of this matter, did you play some role in the follow-up investigation?
Yes.
And were you requested to provide certain documents as part of the investigation?
Yes, sir, I was.
And who requested that assistance?
Bureau of Criminal Apprehension.
And as a commander, are you familiar with sort of the ways that records are stored at the Brooklyn Center Police Department
Generally, yes.
and how to access them?
Yes.
And were you asked to provide training records relative to Ms. Potter?
Yes, I was.
And were you also asked to provide personnel records with regard to Ms. Potter?
Yes.
And were you able to do that,
Yes.
either on your own or with the assistance of others, I assume?
I got some of them myself, but primarily I coordinated the efforts of others within the department.
And is it your understanding that the Brooklyn Center Police Department has a record retention policy?
Yes.
And so your department may not have records going back the entire length of Ms. Potter's career?
Correct.
And as well with training records, training or attendance at training is kept track of by the department. Is that true?
Yes.
Is that required by the licensing authority, the post board?
I guess I don't know specifically what post board requires that we submit, but we do have to track whether or not our staff is receiving their continuing education in specific topics.
And does the Brooklyn Center Police Department provide training on its own for its officers?
Yes, we do.
And do you also allow officers to train outside the department?
We do.
Can you just kind of describe what that would be, what kinds of things that might entail? The outside training?
I guess I'm thinking two different things right now. I'm thinking maybe there's an outside vendor that's offering some kind of training that we will send our officers to. And I'm also aware of some of our officers obtaining training on their own. They go to their own class that they pay for and arrange on their own.
Yeah, that's a much better way of explaining what I was trying to ask. So they can go outside the department to get training if they can find the right program or want to do it.
Yes.
But otherwise, you try to provide enough training at Brooklyn Center for the officers to meet their requirements?
We've always provided more than enough training to satisfy the post requirements, yes.
Since becoming a commander, have you had a role in overseeing the provision of training to officers in the department?
Yes.
Can you describe that for the jury, please?
I've had kind of a broad stroke over the training as far as just monitoring that it is taking place, that everyone is satisfying the requirements. I'm not an actual trainer. I've got people that specialize in that and have been trained in that. I really just kind of monitor that it's getting done, that the training we're providing is accurate, is within best practices, continues to evolve as laws change, as technologies change, as experiences change.
Do you supervise those trainers? Does that make sense?
Sure, I oversee. I'm accountable to the chief to make sure that the training takes place and is appropriate.
In that way, in that capacity, do you work with the trainers with regard to the training they're doing?
Yes, not necessarily the nuts and bolts of exactly what's going to take place, but I get an overview of what the plan is, what the objectives are, what the process is going to be, and ultimately I have the final say on if that's what we're going to proceed with or not.
So probably the better question for me to have asked was, do you review lesson plans, materials that are going to be provided for training?
Yes.
And in that capacity, do you interact with the trainers?
Yes.
And do you also have to go through that training?
I do.
So some days you may sit through a training that you already had reviewed to make sure it was a good training.
Yes.
I want to turn your attention now to Brooklyn Center Police Department policies. Does the Brooklyn Center Police Department have a policy manual?
We do.
And does that contain specific policies within that manual?
Yes, it's a variety of policies.
Why do you have a variety of policies for police officers?
State law requires that we have certain policies. There's I'll call it a small set of policies that we are mandated to have. I think if you're going to run a business, you need to have a collection of policies. It helps establish standards. It communicates expectations. And when running a business, it really helps drive us towards consistency as far as how our officers are going to carry out their tasks.
And are the officers, are these written policies?
They are.
And are officers required to know them?
Yes.
Are they required to follow them?
Yes.
And how did Brooklyn Center come about having these written policies? Where do they get them from to start?
Our policies have evolved over time. Right now, we use a company, a system called Lexipol. It's a national system or a national company. I think we transitioned to them spring of 2014-ish. It's a company that's used by, I believe, over 8,000 agencies across the country. They suggest policies for us based on state law, federal law, changes in state or federal law, changes in case law, evolution of best practices, new technologies. And so they're constantly tweaking the policies, and what they do then is provide input or suggestions, recommendations to us. Ultimately, it's our decision what we're going to incorporate, what we're not going to incorporate. Obviously, we incorporate the things that are in compliance with changes in law or best practices. And so that's how we have really moved forward with our policies in the last 6 years.
And so it sounds like, if I can just make sure I understand, you get a standard sort of from Lexipol. You see if it needs to be altered for Brooklyn Center purposes.
Yes, they provide recommendations or changes to our current policy based on changes, a variety of changes, and then we ultimately make the decision what we're going to incorporate, if we're going to change it, if we're going to take it as is. And sometimes it involves a dialogue back and forth with the lawyers and attorneys with Lexipol to make sure that we are establishing the policy that we're comfortable with and is in compliance with a variety of requirements.
And have you been involved in that process of making adjustments to policy?
Yes.
And just, I guess, to help us all out, how do you spell Lexipol?
Lexipol.
And are there, on occasions, changes made to the policies?
Yes.
And is there a way that those changes are recorded by the department, like when they're made?
Yes.
And can you explain that to the jurors, please?
Although we can print out our policy manual, it's, I think last time I checked it was about 700 pages. It's extensive. The primary way we access it through is a web-based portal online where we can go in, review a policy. If there's a new policy or change, it will get a notice sent out to the staff via email. Each staff member has a unique login, username and password. They log in, they'll be able to review that update or change to the policy, and then they acknowledge electronically by a couple of clicks on the computer, and then it's documented. And then in administration, I can go back and audit that at any point to see when policies were released and when they were acknowledged by staff.
So this program keeps track of when the change was put out
Yes, I'll call it when it was published or when it was released
and released to whom?
to our department.
Okay. And in what ways are those policy changes communicated to the officers?
They'll always come out via email, a notice, an automated notice by Lexipol, but then we generally will also let everyone know, remind everyone. More significant policies, we'll have sergeants review them with the staff at roll call or at a meeting.
And so does this program then record in some way that if each individual officer has acknowledged the change?
It does.
And how is that done? How do they make that acknowledgement?
One or two boxes they have to click at the bottom of the policy on the screen.
And they do that remotely from a computer?
From a computer once they've logged in with a unique username and password.
And when there is a new policy change, are they required to acknowledge it
Yes.
and then expected to know it?
Yes.
You indicated, I believe, that you have access to the program that keeps track of the changes and the acknowledgments by the officers, correct?
Yes, it's the same program. It's just my credentials give me access to different parts of the program that the other staff doesn't have.
And as a part of this case, were you asked to go in and audit the changes to policies and when Officer Potter at the time acknowledged them?
I was.
And does that produce then, I'll just call it a spreadsheet of those policies, dates, and dates?
Yes.
And would it assist your testimony today to have a copy of that spreadsheet with you there on the stand?
It would.
And do you have a copy there with you?
I believe I do.
And so, Your Honor, I'd ask that the witness be allowed to have that there to refresh his recollection about those specific dates as we go through the individual policies.
You have my permission.
Thank you.
Now, I want to draw your attention to specific policies of the Brooklyn Center Police Department. And so at this time, Your Honor, what I understand is subject to stipulation by the defense. I would offer Exhibit 336.
And 336 is already into evidence, is that correct?
No, Your Honor, I'm saying that defense counsel told us they were stipulating to our exhibits.
Okay. 336 will be in evidence.
And if we can,
If you need
and
to.
now I'm going to show you Exhibit 336 on the monitors there. Can you tell us what part of the Brooklyn Center Police Department policy manual this is?
This is one of the first pages that just documents the law enforcement code of ethics.
And why Well, why is this the very first page?
It's important to establish standards and expectations.
And the first line, which I will, if I'm technically savvy enough, highlight for you. You see this line here.
Yes.
What does that mean? First of all, read it to the jury if you would and tell us what it means to you as a police officer.
As a law enforcement officer, my fundamental duty is to serve the community.
Why is that there in the first line of the Code of Ethics?
I believe that's the core of what we do, is we serve and protect.
And I want to go down to the second paragraph. The second line starts with, I will maintain. Can you read that sentence for the jurors, please?
I will maintain courageous calm in the face of danger, scorn, or ridicule, develop self-restraint, and to be constantly mindful of the welfare of others.
Why are those terms there?
It's a difficult job at times, law enforcement, and we need to continue to strive to be our best.
In the third paragraph down, it starts with, I will enforce the law courteously and appropriately, without fear or favor, malice or ill will, never employing necessary force or abuse. Why is that in this policy, that language there?
Objectiveness, units, obviously, it's there. They're relevant. It's a policy. Why it's there is irrelevant.
All right, counsel, are you going to go through this line by line, or?
Some of them, Your Honor, yes, because I don't know if you want me to fully respond, but it is relevant from this commander's perspective and other
Can we
issues.
have a sidebar, please? All right, counsel, you may continue.
So why is it that this unnecessary force language or abuse is right in the Code of Ethics?
Force is significant if we use, and we don't want to use unnecessary force.
In the next line, it talks about the badge of my office as a symbol of public faith. How do you see that fitting in, that language, with your role as a police officer?
I think police officers have an incredibly important role in society. There's statutory requirements or statutory limitations, but I think there is a very special social contract that exists between police officers and the community. Police officers are an extremely forward-facing arm of the government, and it's a special role and relationship we have with society.
You're wearing your badge today, correct?
Yes.
What does it mean when you put that badge on in the morning to you?
It's a reminder that it was given to me by the public to go serve and protect.
The next paragraph down starts with, I know that I am alone responsible for my own standard of professional performance. What does that language mean to you?
I've been trained, I have tools, I have an education, but ultimately I have to go out there and perform well and do my job.
Your Honor, you asked for a standing objection.
May I have a standing objection, which I'm overruling.
And Commander Flesland, as a police officer for the City of Brooklyn Center, are you required to take an oath of office?
Yes.
I'm going to offer formally Exhibit 341 and understand subject to stipulation by defense for its admission.
341 is admitted.
And I will put this up on the screen, Exhibit 341. And Commander Flesland, this indicates upon employment, all employees shall be required to essentially take an oath, correct?
Yes.
Why are officers required to take an oath?
I assume legally there's some kind of requirement there, but I think more important, almost ceremoniously, it's a big deal. It's a special job that we have, and this kind of shows it.
And when you started with the department, did you take an oath?
I did.
I am now going to offer Exhibit 355.
And that's been previously stipulated to, and it is in evidence.
And I'll have this put up on the screen for you. Can you see this?
Yes.
And can you describe for the jurors what this is?
It's a copy of the oath that Kim took when on February 27th of 1995.
And when you say Kim, who do you mean?
Kim Potter.
And so it looks like, comparing to the policy, maybe the language of the oath has changed over time.
Yes, our policies have changed and evolved over time.
But that is still this same oath required.
I believe it has the exact same meaning.
Now, this is taken on the first day of employment, correct? This oath?
Typically.
And at a ceremony?
Typically.
And but does the oath, the requirements of what's said in the oath, continue with an officer as they work throughout the department?
Yes.
And have there been changes made to that policy 102 regarding the oath of office?
Yes.
Can you tell the jurors when the last time was that the oath of office policy was revised?
October 31st of 2016.
And can you tell the jurors the last time or the next time that Officer Potter acknowledged receipt of that change?
August 14th of 2017.
When the department is considering hiring new officers, are there certain qualifications that they look for in candidates?
Yes.
There are certain attributes that the department wants to have in new officers.
Yes.
And are those spelled out in policy as well?
Yes.
That's an expression of those interests that the department has in new candidates.
Yes.
And I'm going to offer Exhibit 349.
Exhibit
We object to that, it's not relevant, Your Honor.
All right. Exhibit 349 is what?
Is the recruitment and selection policy, Your Honor, that council told us previously they were stipulating to admission of.
Stipulated a foundation.
Only relevant.
All right. The objection is overruled. I'll let you continue. And Exhibit 349 is admitted.
I'm going to draw your attention then to what appears to be the fourth page of the policy. And just draw your attention down, if you could zoom into 1000.3.4, the learning ability. And are these attributes that you want to have in an applicant even to be an officer in the department?
Yes.
And that would include, as it says, the ability to comprehend and retain information,
Yes.
to recall procedures, rules, and regulations,
Yes.
laws and statutes and codes,
Yes.
to learn and apply what is learned,
Yes.
to apply the material, tactics, and procedures that are required of the position.
Yes.
Going to the next page, judgment under pressure. If you could zoom in a bit on that. You're looking for people with the ability to apply common sense during pressure situations.
Yes.
Why would that be important in a candidate?
Object to that is irrelevant, Your Honor.
The objection is overruled, and you may answer.
I think that's a good quality to have in any employee.
Particularly officers of the law, is that important?
Object to that as leading.
The objection is overruled, and you may answer.
Yes.
And the ability to make effective logical decisions under pressure.
Yes.
Does the department recognize that officers sometimes have to make decisions under pressure?
Yes.
So in dealing with new candidates, it's something the department wants to look for, the ability to do that?
Yes.
This policy 1000 recruitment, can you tell the jurors when the last time there was a revision to that policy?
August 17th of 2020.
And when did Ms. Potter acknowledge the changes to that policy?
That same day, August 17th of 2020.
So as of August 17th, she was aware of what's in that policy as the jurors have seen it today.
Yes.
And does the Brooklyn Center Police Department expect officers to maintain appropriate conduct when they're on duty?
Yes.
And does the department have a policy on fitness for duty?
Yes.
And I'm going to offer Your Honor Exhibit 351, which is the policy on fitness for duty.
Exhibit 351 will be admitted.
And I'll have that put up on the screen, please. And if we can zoom in on the first paragraph at the top. So it says that all officers are required to be free from any physical, emotional, or mental condition that might adversely affect the exercise of peace officer duties. Why is that a part of the fitness for duty?
We want our officers to be in a good place when they're working. We want them to be ready to execute a very difficult job.
When you are working as a peace officer, is that something you think about when you start your shift?
Sure, maybe not real consciously, but there's been days that I've called in sick if I didn't feel like I could do the job.
And can you tell us the most recent version of this that was sent out to officers?
Most recent one of this policy was September 1st of 2015.
And when did then Officer Potter acknowledge receipt of that?
October 7th of 2015.
Are officers expected to conduct themselves in ways that are consistent with the law and with these policies?
Yes.
If they do not, is there a potential for review of their actions and potential administrative or other consequences?
Sure, there's a variety of things that could result from that.
And is there a policy about that as well?
Yes.
Your Honor, I would offer Exhibit 343, which is the conduct policy.
343 will be admitted into evidence.
Put that up, please. I ask you to go to the second page, please. And zoom in on the paragraph that starts with employees. What we just talked about, is that contained there in that paragraph, that they are expected to follow all applicable laws, ordinances, rules?
Yes.
And would that include policies of the department?
Yes.
And paragraph C, paragraph G, these are circumstances where an officer could face discipline for violations of policy or law.
Yes, there are examples from a lengthy list of things that could.
And C is failure to follow instructions contained in department manuals or city manuals.
Correct.
This policy, 319, the conduct policy, can you tell the jurors last time it was sent out to employees?
September 17th of 2019.
And when did then Officer Potter acknowledge receipt of that?
October 27th of 2019.
Now, you mentioned that police officers have authority to enforce the law, and sometimes the requirement to enforce the law, right?
Yes.
Are they also provided discretion in how they perform their jobs?
Some, yes.
And is that included in the law enforcement authority policy?
Yes.
Your Honor, offer Exhibit 340, which is the law enforcement authority policy.
340 will be admitted into evidence.
Can you go to the second page, please? Here the policy is listed, the policy behind this policy is listed at the very end, correct? So if you could scroll down to the bottom.
Yes.
So highlight that last paragraph that starts with while. Can you read that to the jurors, please?
While this department recognizes the power of peace officers to make arrests and take other enforcement action, officers are encouraged to use sound discretion in the enforcement of the law. This department does not tolerate abuse of law enforcement authority.
Earlier, in response to my question, you said some discretion. Is that an expression of this within policy that officers are given some discretion?
Yes.
Can you tell the jurors when the last time this policy was sent out to officers?
October 15th of 2019.
And when did then Officer Potter acknowledge it?
October 27th of 2019.
Commander Flesland, police officers are allowed to use of force, correct?
Yes.
And is that regulated, shall we say, somewhat by state statute?
Yes.
And does the department also have a policy on the use of force?
We've got several policies that address use of force.
And the use of force policy in particular, is it to be consistent with state law?
Yes.
And is it intended to comply with state law?
Yes. In some areas, I think it may actually be more restrictive than state law, but
And that's something a department can choose to do?
yes.
And so it is sort of encapsulates state law, but maybe a step further.
Yes.
Your Honor, I would offer Exhibit 333, the use of force policy.
333 will be admitted into evidence.
Ask you to put that up, please. I'm going to draw your attention to the first paragraph of this document. And this is an expression of the basic premise, the reasonable use of force.
Yes.
And it indicates that this policy has guidelines for the reasonable application of force, but also other things like control devices and conducted energy device policies, correct?
Yes.
Now, the jury may already know this, but what is a conducted energy device? Is it a fancy name for something else?
We have a taser that is that device that we use.
So this second paragraph, why does it mention also the control devices and conducted energy device policies?
I think this introduction is trying to get into that there needs to be reasonableness in force that's applied. It also recognizes that I don't believe there is any set of policies that could really address every situation that a peace officer will encounter.
Is the use of a taser a use of force?
Yes,
And so is there a separate taser policy?
there is.
And is this paragraph also, does it indicate whether an officer is supposed to incorporate both of those? Does that make sense? The taser policy and the use of force policy?
Yes, I would almost say that this policy 300 is an overarching umbrella that covers all use of force, and then within our policy manual, we'll get more specific on some of the tools and tactics and techniques.
Okay. And If you would scroll down to the bottom of the page, please. The policy is listed here. Draw your attention to the first line. Use of force is a matter of critical concern both to the public and the law enforcement community. Can you explain, in your mind, why that is a matter of critical concern?
Not many jobs or professions or careers are you authorized and mandated in times to use force. It's a significant reach of the government.
And so that's what's critical about it, right? I mean,
use of force is significant, and it's going to play into any kind of ongoing relationship between the police or the government and the community and society. This, I think, just tries to signal how critical it can be.
Now, the next paragraph talks about officers having an understanding and appreciation for their authority and limitations. Is that true?
Yes.
Why?
We are, peace officers are in a unique role. We've got a unique set of responsibilities, tasks, mandates, and I want our officers to always be aware of that special position, that special job that they have.
And then I would ask you to scroll to the next page. The top paragraph, the policy continues. What is that first line about?
The Brooklyn Center Police Department recognizes and respects the value of all human life and dignity without prejudice to anyone.
And so the second sentence appears to acknowledge the ability to use force.
Vesting officers with the authority to use reasonable force and to protect the public welfare requires monitoring, evaluation, and a careful balancing of all interests.
What interests are being brought up there?
I think essentially all interests. Again, it just speaks to the unique relationship between law enforcement and the community.
Now, I'm not going to spend a lot of time on teaching the application of force with you, but I do want to just touch on a couple areas. So if we could scroll down to 300.3. Fair to say that this is the basic statement about the amount of force that a police officer can use.
Yes.
So the first line, the amount of force that reasonably appears necessary given the facts and circumstances perceived by the officer at the time to accomplish a legitimate law enforcement purpose.
Yes.
And from there are a lot of other provisions in the policy, but is that the basic explanation?
Yes, that's, I'll call it foundational, is any force used should only be reasonable.
And we see the second paragraph talks about judged from the perspective of a reasonable officer on the scene at the time, correct?
Yes.
And the officers have to make quick decisions sometimes.
Yes.
And in evolving and changing situations, correct?
Yes, the real world changes constantly.
And are your officers expected to take those things into consideration when using force?
We expect them to make good decisions using new information that becomes known to them.
And the third paragraph there, I think the first line is something you've already referred to. It's hard to predict every factual situation, right?
Yes.
But what's the last line of that paragraph?
Officers are entrusted to use well-reasoned discretion in determining the appropriate use of force in each incident.
Now, as long as we're here, please scroll down to 300.3.1. That's an acknowledgement that officers have the authority to make a lawful arrest, correct?
Yes.
And that would include, for instance, on a warrant.
An arrest warrant, yes.
And if we can scroll down to 300.3.2, this lists the factors that could go into determining the reasonable use of force, correct?
Yes.
And is it your belief that this is consistent with constitutional and state law?
Judge, I object to that as a senior witness, not qualified to give that opinion.
Okay. Do you want to lay additional foundation, counsel?
Sure. In approving these policies or being part of that process, have you become familiar with the constitutional and state law standards or the factors used to determine reasonable force?
Generally, yes. Generally, yes.
And have you also learned those through training?
Yes.
And you've reviewed this policy yourself before today?
Yes.
And are these the kinds of factors that go into determining the reasonableness of force that's used?
I believe so, yes.
And would you expect officers in your department to take these things into consideration in deciding whether to use force or what force to use?
When determining how much force, yes.
And one of those is the immediacy of and severity of a threat to officers.
Yes.
And if you could scroll down, please, to the next page. The seriousness of the suspected offense, another one of those factors.
Yes, sir.
Potential injury to officers, suspects, and others is one of those.
Yes.
Also the risk and reasonably foreseeable consequences of escape,
Correct.
as well as the apparent need for immediate control of the individual.
Yes.
If you could scroll down to the next page to 300.4. And does the policy also speak to the use of deadly force?
It does.
And is there also state law describing the use of deadly force?
There is, yes.
Is that in fact actually cited right here in the policy?
Yes.
And so is it your belief that the policy here is consistent with state law?
Yes.
Just below that is a provision on moving vehicles, correct?
Correct.
And why does the use of force policy have a separate section on moving vehicles?
I guess I can't specifically say why it's in this policy and not another policy, but when we look more at 300.4, you're going to see some reference to deadly force.
Okay, so let's scroll down to the next page and explain to the jury what you mean.
We wanted to articulate here that shooting at a moving vehicle or from a moving vehicle is significant. When, as the policy outlines, when feasible, officers take reasonable steps to move out of the path of an approaching vehicle instead of discharging their vehicle at a vehicle or any of its occupants. An officer should only discharge a firearm at a moving vehicle or its occupants when the officer reasonably believes there are no other reasonable means available to avert the imminent threat of the vehicle or of deadly force other than the vehicle is directed at the officer or others. We want to discourage officers from being in a position where they could be struck by a moving vehicle, but yet we never want to take away the ability for an officer to defend him or herself or another.
Why do you want to discourage shooting at the occupants of a vehicle, of a moving vehicle?
Moving vehicle.
Okay. All right. Excuse me. Mr. Ray, would you please ask to have a sidebar instead of doing talking objections? All you have to do is ask sidebar, and I'll do that. Are you done? I think he corrected himself, And he now, Mr. Frank,
Your Honor,
you are corrected, correct?
I don't know if the court heard me, but while he was objecting, I was correcting myself, attempting to. So my question is, why do you want to discourage shooting at occupants of a moving vehicle?
If it's to stop the vehicle, my understanding is that's rarely effective.
If you were to injure in some way by shooting the driver of the vehicle, what could happen?
A variety of things could happen.
Like what?
Judge, I object to this as well under Rule 403.
The objection is overruled.
The vehicle could strike something or somebody.
I'm going to ask to scroll down to 300.8. Does the policy speak to training?
Yes.
And does it require that officers be trained on the use of force policies and law?
It does.
And how often do they have to be trained on that?
At least annually.
And do you believe that that happens at the Brooklyn Center Police Department?
Yes.
This use of force policy, can you tell the jurors when the last time it was sent out to officers?
December 8th of 2020.
And the last time that then Officer Potter acknowledged it?
December 29th of 2020.
Separate from use of force, is there a separate policy on firearms?
There is, yes.
And I'm going to offer Exhibit 306, Your Honor, which is the policy on firearms.
306 will be
And, oops, my mistake. I got the wrong exhibit number. 342, I'm sorry. It's policy 306, correct? Do officers carry a firearm every day when they're on the job?
Unless they're on light duty or some kind of administrative detail.
Yeah, I should have been more specific. When they go out on the street, do they carry a firearm?
Yes.
And so this policy, drawing your attention to the 306.1.1, so they are required to complete departmental training regarding the use of force and deadly force and firearms before being authorized to do that, to carry it every day, correct?
Yes.
And does your department provide that training?
Yes.
And how often is firearms training provided?
Ideally quarterly. At a minimum, everyone will qualify with their firearms once a year, and then we try and incorporate additional firearms-related training throughout the year.
And when you say qualify, what does that mean?
There's a course of fire, specific distances, some time frames, some positions and orientations you're shooting from. It's a qualification. It's a pass or fail evolution.
So officers are required to fire their firearms,
Yes.
and at least annually,
Yes.
and that means having them in their holster and drawing them and using them.
Yes.
And they're, I don't want to say graded, that seems a little elementary, but
They're evaluated.
and if we could scroll down to 306.5. Draw your attention to the first line of that paragraph or that section. What does it say?
Members shall not unnecessarily display or handle any firearm.
And I actually meant the sentence before that first, but
Members shall maintain the highest level of safety when handling firearms and shall consider the following.
and then not to unnecessarily display or handle. Correct?
Yes.
As one of many reasons, but you expect officers to have the highest level of safety.
Yes.
Is that part of firearms training and how to safely handle firearms?
Yes.
We see a lot of references in the training to low light training. Can you describe for the jury what that means?
When low light is referenced in the policies, it's getting at either at night or maybe in a building without lights on, basically in the dark. Post mandates are part of the annual firearms qualification, also includes some training in low light and inclement weather.
The reality of police work, right?
Especially in Minnesota, yes.
Yes. So that's all part of the firearms training, those differing conditions.
Yes.
And can you tell the jurors when the last time this firearms policy was sent out to officers?
September 7th of 2017.
And when did then Officer Potter acknowledge it?
October 9th of 2017.
Has the department incorporated a policy on vehicle pursuits?
Yes.
And just to, can you basically describe what's covered by the vehicle pursuit policy? What kind of conduct are we talking about?
When officers may engage in pursuing a vehicle, a car chase, what types of situations that could be warranted and authorized in, what types of situations it's not. It goes into a variety of factors that we ask the officers to constantly reevaluate during the course of a pursuit on whether or not it should be continued or not. And it gets into some tactics.
Your Honor, I would offer Exhibit 338, which is the vehicle pursuit policy.
338 will be admitted into evidence.
I'm going to draw your attention to the second paragraph, the philosophy paragraph. You see the second line starts with a sentence with "in recognizing." Can you describe for the jurors that language there?
In recognizing the risk to public safety created by vehicle pursuits, no officer or supervisor shall be criticized or disciplined for deciding not to engage in a vehicle pursuit or for terminating a pursuit already underway, even if permitted by state statute and department policy.
Sounds like that's giving officers some protection. They're not going to be judged later if they terminate a pursuit.
We want to take away any kind of unnecessary pressure that the officer might feel if they are making a decision that a pursuit is maybe too dangerous for them to continue.
On the second page, the policy addresses when to initiate. At number 1, and on the next page there is a number 2, correct?
Yes.
And to initiate a pursuit, there is in number 1 a list of crimes that officers in your department are authorized to initiate a pursuit for, correct?
Yes.
And do any of those include a gross misdemeanor warrant?
Not these probable cause crimes, no.
Now, if we go to number 2 on the next page, there is another provision for initiating, and what is required under that provision to initiate a vehicle pursuit?
The pursuing officer or officers have reason to believe that there is an imminent safety risk to the public or an officer if the driver or one of the occupants of the vehicle is not immediately apprehended.
So those are the sort of two bases upon which an officer could initiate pursuit.
Yes.
A little farther down on that page, 307.6, factors in initiating or continuing a pursuit. So these are things officers are expected to consider, correct?
Yes, these are some of the things that they should be evaluating throughout a pursuit,
Or even initiating a pursuit.
or even before a pursuit is initiated, yes.
In paragraph F, one of those is the ability of the officer to identify the driver at a later time.
Yes.
At the very bottom of that page starts the section on terminating a pursuit, correct?
Yes.
And one of those factors is in paragraph C, the identity of the offender is known and delaying apprehension does not create a known and substantial risk of injury or death to another.
Yes, that's a possible factor to consider.
Can you tell the jurors when the last time was that this policy was sent out to the officers?
March 11th of 2021.
And when was then Officer Potter, when did she acknowledge it?
April 6th of 2021.
Now, this is news to me, but is there actually a policy on foot pursuits even?
We do have one, yes.
Why is there a separate section on foot pursuits?
It's a significant event for an officer to participate in. Although there are some overlaps as far as concepts and thought processes with vehicle pursuits, there's also some unique aspects to foot pursuits as opposed to vehicle pursuits.
Your Honor, I would offer Exhibit 346, which is Policy 425, the foot pursuit policy.
346 will be admitted over defense of protection.
Put that up, please. And drawing your attention to the second paragraph under the policy, there is language here about absent exigent circumstances. Safety of the officers and the public should be primary consideration when determining whether a foot pursuit should be initiated or continued, correct?
Yes.
Now, what does that last line say?
Officers must be mindful that immediate apprehension of a suspect is rarely more important than the safety of the public and department personnel.
So again, here is a balancing of interests in deciding whether to initiate or pursue a foot pursuit.
Yes, another example of the risk-reward analysis that our officers must make frequently.
And if we go down to the bottom of that page, sentence that starts with, if circumstances reasonably permit, what are some other options besides a foot pursuit that an officer can do, basically drawing your attention to the first line there of that paragraph?
Containment of the area.
So surveillance means what?
Surveillance, setting up a perimeter, saturating the area with peace officers to try and locate the individual or individuals.
And then on the next page is paragraph E. And what does this paragraph speak to?
Apprehension at another time, when the identity of the suspect is known or there's information available that would likely allow for later apprehension and the need to immediately apprehend the suspect does not reasonably appear to outweigh the risk of continuing the pursuit. It's getting at another approach you could take in response to someone fleeing on foot.
Can you tell the jurors when the last time is that this policy was sent out to officers?
September 1st of 2015.
And And when did Officer Potter acknowledge it?
October 12th of 2015.
Members of the jury, we're going to take a 20-minute break, okay?
Can I just leave this up here?
Yes, you may. All right, Counsel, we should probably talk about this Blakely issue, whether it's going to be a unitary proceeding or a bifurcated proceeding. I know we're getting ahead of ourselves again because the Blakely would not come up unless there were a guilty verdict, but I think we should discuss this now because it might impact what evidence goes in as we go forward.
Yes, it's our position.
Oh, could you put your microphone, maybe switch places with, no, why don't you go to the podium, Mr. Gray?
Your Honor, it's our position that we did not agree to try the Blakely issue along with the jury trial. Neither did our client. If Mr. Prosecution thinks that we did, we didn't, and I don't think there's any record of us ever doing that. In order to do that, we would have to first get permission of our client. What I understood was that if we would lose the jury trial, after the jury trial, we would have a bifurcated trial with the court and let the court decide the Blakely issues. I would never agree to combine both of them. That was my understanding, and I believe it was Mr. Ames and our client. Thank you.
Your Honor, we absolutely did discuss this in chambers with counsel. We did talk about leaving the determination of the Blakely issues to the court rather than the jury. Counsel indicated that their client would agree to that. Not a huge, real surprise to anybody that does this. And then we talked about still having a unitary trial, not a bifurcated trial. And it was agreed to by everybody in the room. Now, Ms. Potter, of course, was not in the room at that time, but her attorneys represented at that time that they would not be requesting a bifurcated trial, that we were going to have a unitary trial. And I'm a little bit concerned that counsel is now saying on the record, absolutely, we did not agree to that, because we did agree to it. It was discussed and agreed to. Now, having said all of that, again, as I said this morning, this evidence disputed today is going to come in for two purposes, the Blakely purpose as well as the fact that it's relevant to Ms. Potter's job then as a police officer, and that goes to her awareness. But additionally, Your Honor, we had a real brief discussion, is my recollection, about the recognition that the Blakely-only evidence would be very minimal, that most of the evidence for the Blakely factors would be relevant to the guilt factor, or the guilt issues anyway. And so practically there would be no need, or very little need, for a bifurcated trial. And so we do need to make a record that Ms. Potter is waiving her jury rights to the Blakely factors if they are going to stay with that position. But I firmly recall saying to the court that we would have then a unitary and not a bifurcated trial, and that was agreed to. That's the way we've proceeded with the proof in this case. And really, I think, as we talked the other day, just a little bit about the injuries to the other people down the street, there's been very little Blakely only information anyway, if really even at all.
All right. I think everybody has kind of a different recollection. I'll tell you mine. I remember the issue coming up. I remember the defense saying that they wanted me to decide the Blakely issues. I don't recall that we went into any detailed discussion whether it would be a unitary or a bifurcated proceeding. I specifically do recall that a unitary trial on both was not agreed to. I don't think we discussed it at all. And I think counsel has a different memory of it. But my recollection is that we didn't discuss unitary versus bifurcated.
As a prosecutor, we are very sensitive about Blakely issues. I mean, we know this is something that has to be handled. It's in the rules, unitary or bifurcated. So with all due respect, I do specifically remember bringing up whether it be unitary or bifurcated, and we talked about it being unitary because there would be so little evidence, really, if any. Now, if you really recall last week, after some testimony about the crash afterwards, this came up, and we discussed it then about there being a unitary trial, and this claim that counsel's trying to set up now, that there's some error here, wasn't brought up then. It was discussed that we were having a unitary trial on it, and that's how it was to go forward. Now, I want to add to the court, I think, that really, I think almost all of the evidence has been admissible on both issues anyway. So there is no prejudice from not having a bifurcated trial so far.
Okay, I don't think there has been any prejudice so far because the second crash relates to reasonable use of force with the taser in a allegedly moving vehicle. So I don't think there's been any prejudice, but what I think we need, I don't think it matters what our respective recollections are anymore, because what is critical is Officer Potter was not in chambers with us. There was never a record made of her agreement to have a unitary trial. The defense is now saying Officer Potter does not want that, so we're going to go with that. We're not going to have a unitary trial on Blakely and the main issues. Okay? So,
Your Honor, one of the reasons that Ms. Potter never spoke to it is because she was never required to come to court. We never had the ability to make a record with her here until the first day of trial. Because we did want to make that record. She wasn't here. So, but my understanding of the court's ruling is I'm going to try my case the same. If counsel feels that there's no doubt they will object if they feel something is Blakely evidence, and we'll have to just dispute it at that point, I guess. But my understanding is you're not going backwards and striking any testimony or finding that there has been any prejudicial testimony presented so far.
I don't see any. Why don't we do this right now, just so we have a clear record? Counsel, could you deal with the Blakely issue and your client's wishes on that issue for the record?
Yes.
And Mr. Gray, could you put that microphone near your mouth, because the court reporter has been having difficulty.
Yes.
Okay, and put, Mr. Ng, could you put the microphone closer to your client? And you've got a microphone too. Mr. Ng, there's another microphone sitting right there. Okay. All right.
Your Honor, we do not intend to have one trial. If our client is convicted, we would want a bifurcated trial and try the likely issues after the factual issues in the trial. And we've never, ever discussed with our client about waiving that. I don't believe that anything was discussed in the chambers about this issue. We said we would try it to the court after the case is tried, which I assume would be a bifurcated trial. In any event, our client wasn't there ever, and she will not waive any right not to have a bifurcated trial.
Okay. And just to be clear, should there be guilty verdicts in this case, that issue will be submitted to me. And therefore, there won't be any evidence pertaining to Blakely during the main trial here. Okay.
I'm sorry.
Yes.
Ms. Potter needs to do a jury trial waiver of her Blakely issues. A formal waiver needs to be done on the record, and now we have learned the hard way why, but that still needs to be done. She needs to waive the jury trial on Blakely issues and decide on a bifurcated process.
Okay. Ms. Potter. Let me find her. There are two Blakely issues that the state has submitted, and the two Blakely issues are that defendant's conduct caused a greater than normal danger to the safety of other people as she fired into a motor vehicle in which a passenger was present and two other officers were in close proximity while the vehicle was operational on a busy public street. After defendant fired, the vehicle traveled down the street and struck an unoccupied vehicle heading in the opposite direction. That's the first alleged Blakely factor. The second one is that defendant abused her position of authority as she was a licensed police officer in full uniform who had seized Mr. Wright. And I'm sure that your attorneys have explained to you what Blakely is all about, but those issues would not be an issue at all if you were found not guilty of either charge. If you were found guilty of one or two of the charges, your attorneys have indicated that they want me to decide whether these aggravating factors exist. The aggravating factors generally would allow me to impose a more severe sentence. Now, you have the right to have a jury decide these the existence of these aggravating factors. You have the right to call witnesses. You have the right to cross-examine any witnesses that the state would call. And I suppose you'd have the right to testify, too, if you wanted to, on those issues. You'd be represented by counsel. And the jury would have to find beyond a reasonable doubt that these factors existed. And the burden would be on the state. Is it your wish to give up your right to a jury trial on whether or not the two Blakely factors exist in the event of a guilty verdict?
Yes, Your Honor.
Okay. Counsel, do you have additional questions on the waiver?
No.
Okay. Does the state have additional questions on the waiver?
Yeah, I would just ask the court, or I could ask if the defendant if you want, but to acknowledge that she has discussed this with her attorneys. She's had a sufficient amount of time to discuss it, and she doesn't need any more time today before making this waiver on the record.
Okay. You've had time to discuss this, right, with your lawyers?
Yeah.
Do you need more time to think about it? Okay. All right. Okay, counsel, let's take a 15-minute break. Okay. Sorry. Thank you, Deputy. Yes. Okay, please be seated. All right, Counsel, you may continue.
Thank you, Your Honor. Commander Fleslin, when we left off, I was about to ask you about officer-involved shootings. Has the department developed, through Lexa Bowl, a policy on officer-involved shootings?
We have, yes.
Your Honor, I would offer Exhibit 337, which is that policy, 305.
337, you admitted.
And this is another one we're not going to go through at length, but can you tell the jurors why you have a separate policy about officer-involved shootings in such incidents?
I would say first and foremost the significance and severity of such an incident, but it can be a slightly unique investigation to work through, and we just want to make sure that we've thought through everything ahead of time, have some best practices, have some guidance that we can lean on, that we can work through this sort of situation if it ever happens.
And in this case, did your department refer the investigation out to an outside agency?
We did.
And which agency was that?
The BCA, the Bureau of Criminal Apprehension.
And why was that done?
Well, we've long known that you're going to have someone else investigate it, and there's been a lot of movement through the state legislature as well as others as far as which agency is the maybe the preferred or the ideal one in Minnesota.
And so, the bottom line there is to have an outside agency do it.
Yes.
And if we zoom in on the policy provision here, 305.2, is that the reason for that expressed here?
Yes, the policy of the Brooklyn Center Police Department is to ensure that officer-involved shootings and deaths are investigated in a thorough, fair, and impartial manner.
Even though the department refers the investigation itself to an outside agency, does the department still have some responsibilities? No, strike that. Does the department and its officers still have some responsibilities at the scene initially?
Absolutely, yes.
And if we go, to 305.5.2, so this provision spells out responsibilities for supervisors at the scene, correct?
Correct.
And fair to say that I'm trying to speed this up to say, like, they supervisors get some information, control the scene, and then pass it on.
Generally, big picture, yes.
And securing the scene is part of the responsibility there.
Yes.
Preserving the integrity of evidence. If we were to go down a little farther, this would be just above 305.5.6. See on this page at care should be taken to preserve integrity of any physical evidence.
Yes.
So it's within the department's policy to secure relevant evidence before turning it, so that it can be turned over to the outside agency.
We want to safeguard the scene and the evidence as best we can.
And then the policy seems to separate between involved officers and uninvolved officers, correct?
Yes.
And bottom line for involved officers under the policy is what? Do they have any role in the ongoing investigation, uninvolved officers?
Not a significant active role that they're going to be taking actions on their own.
And involved officers, generally what is provided for in the policy regarding them?
Big picture, we're going to get any involved officer away from the scene. We're going to get them back to a secure location, probably the police department. We're going to make sure that physically any kind of injuries are evaluated and treated. We're going to work to help them contact union representative to help ensure that safeguards and everyone's rights are intact.
Now, I asked you earlier about the field training officer program at Brooklyn Center. You're familiar with that?
Yes.
And is there, in fact, a field training officer policy or program policy in Brooklyn Center as well?
There is, yes.
Your Honor, I would offer Exhibit 344, which is the FTO program policy.
Exhibit 344 will be admitted.
And can you put that up, please? And then if you can, zoom in on the second paragraph. So this defines the policy of the department to put new officers in a structured field training officer program, correct?
Yes.
What is the purpose of the FTO program?
It's really to indoctrinate the new officers into police work in Brooklyn Center. They've already passed all the requirements by the state as far as licensing. They've got a license. They've demonstrated competency and skills in other academic programs. And now we're going to work to make sure that they know how to be a Brooklyn Center police officer.
And the policy here seems to indicate that, well, is it the intention to have that new officer acquires the skills needed to operate in a safe, productive, and professional manner?
Yes.
And does any officer get to be a field training officer?
No.
Are there requirements for that spelled out here in the selection and training provisions?
Yes.
And the first paragraph, the FTO is an experienced officer, correct?
Yes.
And trained in the art of supervising, training, and evaluating entry-level and lateral police officers, correct?
Yes.
And if we scroll down a little bit farther, does this speak to training?
This part speaks to the selection of who we're going to have as a field training officer.
Yeah, I was a little imprecise there. Below the selection process, continued training.
Yes.
Are Brooklyn Center FTOs required to be trained?
Yes.
Now, I'm going to, do you know if Kim Potter was working as an FTO on April 11th of this year?
She was.
And in obtaining the personnel records, are there records concerning her training for being an FTO?
Yes.
And Your Honor, I would offer Exhibit 391. Can you describe for the jurors what this is? And this is, I think, actually a two-page document, so I'll have you just explain both pages.
This first page is just a training notice that one of our administrative staff would have sent out notifying Kim Potter that she was scheduled for FTO basic certification. It was training began February 7th of 2011. It was a one-week course, ended on the 11th of 2011. And then once Kim finished the training, she signs it acknowledging that she finished it and submits it back to our administrative assistant to file and log it.
And does this appear to be her signature at the bottom?
Yes.
And if you can go to the second page of that exhibit, what is this?
It's the certificate of completion. So my assumption is this is what she got at the end of the training course. She returned back to the police department. When she submitted the signed confirmation slip acknowledging that she attended the training, she also submitted this certificate, just helping to show that she was there.
And this indicates, well, if we can go back to the first page, up at the top it says description of training, basic certification, correct?
Yes.
So would this be the first training as an FTO to be an FTO?
Yes.
And then Your Honor, I would offer Exhibit 392. And can you describe this for the jurors, please?
It's another training notification slip. This one, description of training, is FTO update. The dates were in April of 2013, so this would have been, I assume, the first refresher course that Kim attended.
And is that her signature down at the bottom?
Yes.
And then finally, I would offer Exhibit 393, which is another certificate.
$393
Three, correct.
will be admitted.
And do you see this as well?
Yes.
And what is this?
Certificate of completion from when Kim finished another FTO update back in April of 2018.
And Commander Flesland, are you certified to carry a taser?
I am.
How long have you been certified?
Since shortly after we got him, back in 2002 or 2003 timeframe.
What do you mean by shortly after we got him?
When I first started in 2000, we didn't have tasers. Eventually, when we first got them as a department, there was only a handful of officers and sergeants that were allowed to carry them. They were the ones that had gone through some CIT training. And then eventually, shortly thereafter, we rolled it out to all of the whole department. So initially, I wasn't part of that small cadre of officers that had them.
And what do you mean by CIT?
Crisis intervention training.
Okay. So just, and then, so at some point, did you obtain your initial certification?
Yes.
Was that while you were at Brooklyn Center?
Yes,
And then have you been recertified every year?
I have.
And when you were first certified to carry a taser for Brooklyn Center, how did you carry it? Where on your body did you carry it?
Initially, it was in a drop-down holster on my reaction side, or my side opposite where I carry my handgun.
So by reaction side, just want to make sure we're clear because sometimes there's different terminology. So what side do you carry your firearm on?
I carry it on my right side. I'm right-handed. I'm
And
dominant on my right side, so my left side is what I would consider my reaction side.
And so you've carried your taser on your left side?
Yes.
Is that throughout your career?
Yes.
Why do you carry it on the other side?
That's how the policy has always been, and that's how we've always been trained.
Okay, one last policy, I promise. Is there a specific policy on the use of a taser?
Yes.
Your Honor, I would offer Exhibit 334, which is the taser policy.
It is.
I want to draw your attention to the second paragraph, 304.2 policy. Tell the jurors basically, what's being communicated here? What's the basic role of a taser in policing in Brooklyn Center?
Can I start by just reading it?
Of course.
The taser device is intended to control a violent or potentially violent individual while minimizing the risk of serious injury. The appropriate use of such a device should result in fewer serious injuries to officers and suspects. When we incorporated the taser into our repertoire, it gave us what I believe is a powerful new tool that can allow us more options in a wide variety of situations that hopefully, potentially, are going to minimize any unnecessary violence or injuries.
And, okay, you can take that down, please. Does the taser allow you to use force on an individual from a distance?
It can, yes.
And, well, is training required to carry a taser in Brooklyn Center?
Yes,
Was that laid out here in the policy under issuance and carrying?
it is.
A couple of paragraphs below is a sentence that starts with members carrying. Do you see that?
Yes.
Can you describe what that is, please?
Members carrying the taser device should perform a spark test on the unit prior to every shift.
Do you know what a spark test is?
Yes.
And have you performed that yourself?
Yes.
And is there an exception to this policy provision?
Not that I'm aware of.
And I'm going to have that policy addressed later, so we'll move on right for now. When was the most recent time that this policy was sent out to officers?
September 1st of 2015.
And when did then Officer Potter acknowledge it?
September 23rd of 2015.
When officers like yourself are certified, you have to go through some training for that, correct?
Yes.
And then there's some documentation of that certification, correct?
Yes.
And in your search of the personnel records, did you find some records of Officer Potter being certified?
Yes.
Do you know if she was certified to carry throughout her career at Brooklyn Park once you got tasers?
In Brooklyn Center, yes.
I mean, in Brooklyn Center? And the answer is yes?
Yes.
All right. Do you know if the department has all the records of those certifications or just some of them?
I think we've got a decent collection of them, but I don't think we have every document that we've ever had on the taser.
Your Honor, at this time I'm going to offer Exhibits 246 through 255.
Exhibits 246 through 255 are admitted into evidence.
And I'm going to start in sort of reverse order with Exhibit 255. Do you recognize what's what is Exhibit 255?
I do.
And what is that?
It's Taser certification for Kim back in December of 2002.
Okay.
And it was for the M26, which was the initial model of the Taser that we had.
Have you had some different models over time?
Yes, they've evolved.
So December of 2002, do you recall when Brooklyn Center got those initial tasers?
Probably shortly before that. That sounds like the right time frame.
I'm going to show you Exhibit 254. What is this?
Training certification for Kim when she was trained on the X26, which was a newer version of the Taser. And this was May of 2005.
Showing then Exhibit 253. Can you describe this, please?
This looks like it's a recertification. When Kim recertified with the Taser, it looks like it was the M26 back in 2007.
I just want to take a quick look at this. You would have received a document like this when you were certified, correct?
Yes.
And the name at the bottom where it says print name, do you recognize that name?
Yes.
Whose name is that?
Sergeant Pastor.
Is that Pastor?
Yes.
And do you reckon? I mean, was he one of the Taser trainers?
He was and still is one of our Taser instructors.
And the area above that, where the check marks are,
Yes.
what is the purpose of those check marks?
They were indicating what all had been included in that training session.
And back then was an actual written test required?
Yes.
It appears that Ms. Potter got 100% on that test, correct?
Yes.
I'll show you Exhibit 252. Can you describe this for the jurors, please?
It's the very similar recertification form where Kim would have gotten some more Taser or recertification on April of 2015.
And above the date on that line is a name. Do you recognize that name?
Yes.
Whose name is that?
Officer Knight.
Was she, well, it's a female officer, correct?
Yes.
And was she one of the Taser trainers?
Yes.
So this is Ms. Potter being certified again in 2015.
Yes.
Here's the score of 50 out of 50 on that.
Yes.
And I'll show you Exhibit 251. Can you describe this for the jurors, please?
It's another Taser recertification form where Kim was recertified in November 2016 and was certified by Sergeant Peterson, another one of our Taser instructors.
Okay, and that is Mike Peterson?
Yes, sir.
So that's his name above the date.
It is.
And again, it appears here Ms. Potter got a perfect score.
Yes.
Showing you then Exhibit 250. Do you recognize this?
Yes.
And what is this?
Another Taser recertification form showing that Kim was recertified November 2017 by Officer Knight.
And there is in the middle of the page, and if we can zoom in on the signature there, do you recognize that signature?
Looks like Kim's signature.
Okay. And so the signature here acknowledges what?
Receipt of Taser's version 20 product warnings, understanding that she must read and understand these warnings prior to participating in any hands-on CEW drills required by the certification course.
And if we scroll down a little, there are a series of X's why are those there? What do they signify?
That she participated in those portions of the training. I guess I assume that those are Officer Knight's X's.
And again, it appears that Ms. Potter got 50 out of 50 on the test.
Yes.
Showing you then Exhibit 248. Do you recognize that?
Yes.
And what is that?
Another Taser recertification form showing that Kim was recertified November 12th, 2019 by Officer Knight.
Now above that, instead of X's, we have some initials, correct?
Yes.
Can you tell whose initials those are?
I believe it's Officer Knight's initials.
And above that, if we could zoom in on the signature there, that is the student's signature, which would be Ms. Potter, correct?
Yes.
And again, that's certifying that she understood and read the warnings, correct?
Yes.
And I'll show you Exhibit 247. Do you recognize this?
Yes.
Okay, and what is that?
Another Taser recertification for Kim from November 2020.
Now, at the very top of the page, there's an X by one of the model numbers, correct?
Yes.
And what model was she recertified on at that training?
X26P.
And again, there's her signature below that,
Yes.
and making the same acknowledgement.
Yes.
Below that are the indications of what was covered.
Yes.
The bottom line is blank. It refers to the X2 and X3, correct?
Yes, different models.
And again, Officer Knight, the trainer.
Correct.
And then finally, Exhibit 246. Can you describe that for us, please?
It's another Taser recertification form showing that Kim was certified March of 2021 by Sergeant Pastor.
Now, the title of this form refers to a Taser 7. At some point, did the department move to a different model from the X26?
From the X26P, yes.
Okay. And so what model was this training done on?
This document is showing training on the Taser 7.
And it indicates a transition course, correct?
Yes.
And are you currently certified on the Taser 7?
Yes,
Did you have to go through a transition course when the Taser 7s came?
I did.
And in the middle of the page there appears to be a signature again, correct?
Yes.
And that is for the student.
Yes.
There is underneath that the check marks for what all was involved in that training, correct?
Correct.
That includes a de-escalation warning arc, correct? The third line down.
Yes.
The top line is reviewing the PowerPoint presentation and training bulletins, correct?
Yes.
And can you tell a jury who was the certifying instructor for this certification?
Sergeant Peterson.
Commander Flesland, were you asked to review some videos from prior Brooklyn Center Police Department incidents in which Ms. Potter appears as an officer?
I was.
And have you reviewed those videos and still images from them when Ms. Potter was a responding officer to those incidents?
Yes.
And particularly, did you view dash cam video from a Brooklyn Center Police Department incident on April 30 of 2016?
Yes.
In reviewing that video, did you recognize the squad car as a Brooklyn Center squad car?
I did.
Did you recognize the software running the video as consistent with what your department uses or used back then for video?
It was.
And did you recognize Ms. Potter in the video?
I did.
Your Honor, we would offer Exhibit 382.
Any objection to 382?
No objection.
382 will be admitted into evidence and you may publish.
Now, showing you this photograph, Exhibit 382, this is a still photograph from the video of that incident, correct?
Yes.
And there should be a small stylus in front of you if you want to use that and maybe draw on the screen where Officer Potter is. And when you were watching the video, were you able to discern where she was wearing her taser at that time?
I was.
And I think the two slices of video are attempts at a closer-up view of that, correct?
Yes.
But from watching the video, were you able to determine where she was wearing her taser?
Yes.
And where was she wearing it?
On her left, it was on the left side of her duty belt.
And when officers are wearing their taser, are there two different orientations that they can wear it in?
Yes.
And what are those two different orientations?
I'm going to call them a cross draw and a reaction hand draw.
And what's the difference? And if it would help to demonstrate to the jurors, if you want to stand up and just show them, you can do that if you want.
The way I have mine oriented is for a cross draw. So I'm right-handed, right hand dominant. I carry my handgun on my right side, carry my taser on my reaction side. So this holster is set up so that I would cross draw using my dominant hand to draw across my body. When I refer to a reaction hand draw, the taser would be oriented so the handle is aft, not forward, and you would use your reaction hand to draw the taser that way. So it basically which way the handle is pointed, whether it's going to be forward or aft.
And Exhibit 382, can you tell which orientation Ms. Potter is wearing her taser?
Reaction hand draw, yes.
Did you also review body-worn camera video from a Brooklyn Center Police Department incident on November 2 of 2017?
I did.
Did you recognize the officers in that video?
Yes.
Did you also recognize the computer program running the video as that which your department used then?
Yes.
And did you recognize Officer Potter in the video?
I did.
Your Honor, I'm going to offer Exhibit 383.
383 will be admitted into evidence and you may publish.
And with this on the screen, were you able to determine the side on which Ms. Potter was wearing her taser?
Yes, it was on her left side, her reaction side, and it's set up for a reaction hand draw.
Were you also asked to review body-worn camera video of a Brooklyn Center Police Department incident on February 21 of 2018?
I was.
And in doing so, did you recognize the voice of the officer speaking as a Brooklyn Center police officer?
I did.
Did you recognize other officers in the video?
I did.
Did you recognize the squad car that the video was being taken from?
I did. It was a Brooklyn Center squad.
At this time, Your Honor, I'm going to offer Exhibit 384.
384 will be admitted into evidence and you may publish.
And is this Officer Potter in the video?
It is.
And can you determine how she is wearing her taser in this incident?
It's on her left side, reaction side set up for reaction hand draw.
Were you asked to view body-worn camera video from a Brooklyn Center Police Department incident on November 4 of 2019?
Yes.
And did you obtain the videos for that incident from the Brooklyn Center Police Department records?
Yes.
So if you could just real briefly describe for the jury how you would do that, after body-worn camera video is made, where it goes and how you get it.
For the body-worn camera video,
Correct.
when the recording is done, or when generally at the end of your shift, you'll take your body-worn camera off your body, you'll dock it into a docking station. We've got 8 bay chargers where 8 different body-worn cameras can dock. Once you dock that into the charger, a few things happen. The battery starts to recharge, and any videos that are on it will get pulled off of the body-worn camera and pulled onto a city network. It's a secure drive, it's a secure network, and there's a repository there for the videos. We'll access the videos, or we can access the videos through, again, it's a web-based program or interface. I guess it's not actually a web-based, correct? It's a standalone system on our computers, but we'll log in and we can access the videos. Different people have different rights, different abilities to view videos. Every officer has the ability to view their own video, has the ability to categorize it, attach a label to it, whether it's a case number or such, and then part of that labeling will determine data retention, how long it will be retained for. Certain people, certain supervisors have the ability to go in and view anyone's video. So that's what I was able to do in some of these, is when I had a case that I was going to look at, or a time, date range, I was able to plug that in, pull up all the videos that satisfied that request, and that's how I was able to find these videos.
And did you recognize Officer Potter in the video?
Yes.
Your Honor, I would offer Exhibit 385.
385 will be admitted into evidence and you may publish.
And are you able to determine how Officer Potter is wearing her taser during that incident?
Yes, it was on her left side again, set up for a reaction hand draw.
Did you also obtain video from a Brooklyn Center Police Department incident that occurred on June 15 of 2020?
Yes.
And did you recognize the officer in that incident as a Brooklyn Center Police Department officer?
Yes.
And you obtained this video in the same manner as you did the previous one?
Yes.
Did you recognize Officer Potter in the video?
I did.
Your Honor, I would offer Exhibit 386.
386 will be admitted and you may publish.
Based on this video, and just for the record, this is a still from that video, are you able to determine how Officer Potter was wearing her taser on that occasion?
Yes, it was on her left side, set up for a reaction hand draw.
And for purposes of this, did you also review a portion of Officer Anthony Lucky's body-worn camera video from this incident?
I did.
And Your Honor, I would offer Exhibit 387.
387 is admitted over defense objection and you may publish.
And from that, are you able to determine how Officer Potter was wearing her taser on that date?
It was on her left side, set up for a reaction hand draw.
Now, based on your role as a commander, are you familiar with how records are kept of training attendance?
Generally, yes.
And is there a computer program that you have to keep those attendance records?
We've had a few programs through the years.
Okay. And So is attendance at trainings for officers kept in the ordinary course of business at the Brooklyn Center Police Department?
Yes, they are.
And were you able to obtain a summary of all of the trainings that Officer Potter has attended since being a Brooklyn Center police officer?
As much as our systems were able to allow us to.
And, Your Honor, I would offer Exhibit 335.
Exhibit 335 will be admitted and you may publish.
So I'm going to scroll through this. We're looking at page 1 of Exhibit 335, correct?
Yes.
And, just for lack of a better term, this looks to be kind of a spreadsheet, correct?
Yes.
And this is for Ms. Potter's attendance, correct?
Yes.
So on the left column is in yellow is a date for an entry of the year, correct?
Yes.
And then the blue column, the numbers in blue, are for what?
Date attended.
Then there's a red column, indicates completed.
Yes.
And then there is a type of training column and a name of training column, correct?
Yes.
Do you know who enters that information, the name?
Someone from our records division.
And it also keeps track of the number of hours, correct?
Correct.
And so then if we scroll down, this starts in 2021 and works backwards, correct?
Yes.
And then so let's keep scrolling down until the format changes. Here we see a slightly different version once we start 2016, correct?
Essentially, it's the same. It just appears to be black and white.
Right. So we'll keep scrolling down. Now here we see slightly less robust version of that, correct?
Much less sophisticated.
So this was a previous version of the software you used to record these?
Yes.
Okay. Then let's just keep scrolling down. So these are trainings that go back to 96, correct?
Yes.
Your Honor, those are all the questions that I have for this witness.
Okay. Counsel, you may pause.
That last, it's good afternoon, I guess. It's 1 minute after 12. I gotta get a drink of water. Would it be fair to say, Commander, that our client, Kim Potter, did not miss any training sessions throughout her career?
I'm not aware of any.
Okay. And the exhibit that you just went through with the prosecution, that was a record of her training, correct?
Yes.
And you know Officer Potter from the years you worked with her, correct?
Yes.
And she took her training seriously, did she not?
She did.
However, when you train as a police officer, no matter how much training you do, it's not like real life, like an emergency situation out on the street, is it?
Never exactly, no.
And you don't know how you're going to react until that emergency situation takes place, correct?
Correct.
So, the report that you gave the prosecution, or a statement you gave them, was about Officer Potter, or former Officer Potter, in what she did as a police officer in addition to her job. And do you remember telling them that? I'll refresh your memory. Did you tell them that she worked as a field training officer? We know that, correct?
Yes.
Did she get paid for that?
Yes.
Any extra pay? What about a crisis negotiator team member? Was that a volunteer situation?
She volunteered for it and was selected. Yes.
Okay, and what is a crisis negotiator team member? What do they do?
Sometimes they're referred to as hostage negotiators. They really can work in collaboration with maybe a SWAT team trying to resolve an incident. They're communicators. They communicate with someone that is perhaps committing a crime, perhaps in crisis, a variety of situations where crisis negotiators will try and persuade people to resolve the situation as peacefully as possible.
And do you know how long she was on that program?
Several years. I don't know exactly how many years.
And that's a program that you volunteered, is that right?
Yes.
And with respect to DART, what is that?
DART is Domestic Abuse Response Team. It's a collection of officers and detectives that have volunteered to help address some ongoing domestic abuse or domestic violence incidents. We found through research, and it's best practice, once our officers respond to a domestic abuse sort of situation, they may come up with a resolution for that night, whether it's an arrest or whatever. But we will have volunteer officers that have volunteered for this program reach back out to the domestic assault victims days or maybe a week later. For a variety of reasons, they could collect more evidence. Maybe there's bruises now that appear that weren't visible initially. And then the officers can help, hopefully, establish a rapport with that victim, help them navigate the upcoming process through the criminal justice system, help make sure they have the resources, trying to end the circle of violence.
And she did that for many years?
Yes.
And besides that, she worked as a LEMA. What's LEMA? What does that mean?
Law Enforcement Memorial Association.
And what is that?
It's an organization.
Was she an honor guard representative?
Yes, she was.
Tell us about that.
The organization is set up to support fallen peace officers and their families. The honor guard portion of it performs at funerals of officers that are killed in the line of duty. There's also a variety of other events that they perform and support that fallen officers' families.
And has she done that for many years?
Many years.
And did she volunteer to do that?
Yes.
Now, with respect to her being a union steward and president, was she voted into that position by the other officers?
Yes, by the other officers and detectives in the 82 union.
And so that the jury understands this type of union steward, her only duty is to negotiate a contract with the chief. Is that a fair statement?
I believe there's many more duties besides just negotiating contracts.
And what else would there be?
They're there to represent the officers and detectives, or whoever's in that bargaining unit. They can help that officer negotiate if they believe they've been wronged and are going to potentially go down the grievance route or something like that. The union stewards can help them navigate that process so that
And they're voted in by the other officers, is that right?
Yes, sir.
And that's also a non-paying volunteer job?
Correct. In your 21 years there, has Officer Potter ever been accused by the public or anybody of an abuse of power, use of force? Has she ever been accused of using her position abusively? Not the,
The objection is overruled. You may answer.
not that I'm aware of, sir.
And has she ever been charged with any violation of the policies at the Brooklyn Center Police Department?
I'm aware of some driving incidents with motor vehicle accidents, but
And that was back when she first started, correct?
I believe so, yes.
There was 2 car accidents within the first couple of years, is that right?
That was the version I heard.
And that was about 24, 25, 26 years ago?
That sounds about right, sir.
Now, on these policies that we talk about, excuse me again. First, we'll do the vehicle pursuits. That was policy 307. That policy deals with a vehicle that's moving, correct? Or stopped and took off.
Yes.
For example, if a police officer goes to stop a vehicle and it takes off like a jet, you don't chase it for just a traffic violation. Is that correct?
Generally, no, but that's just one of the factors that would have to be evaluated.
All right. And that has nothing to do with a vehicle that's stopped at the scene and you're executing a warrant for the arrest. Is that correct? About a car fleeing?
I think one situation could potentially lead into the other situation, but generally, no.
But the officer, potentially that would lead in, the officer that stopped that vehicle, or officers, would attempt to stop the vehicle from fleeing, correct?
I guess I'm...
Well, the officer stopped the vehicle. Hypothetical, this case, 3 officers come up and try to arrest the individual for a warrant, trying to find out who the TRO, if the girl in the car is the person in the TRO. No license, no insurance, no real identification. Would they be in their right to stop that person from fleeing once he was stopped and he was outside the car?
Object, Your Honor. This statement.
The objection is overruled. You may answer.
Based on the way you laid it out, yes.
Well, what difference did I make from what actually happened here that day, sir? Was there something I didn't add?
I haven't investigated what happened here this day. I have limited knowledge of the particulars of this.
Okay. Have you looked at the videos, the body-worn camera videos of this incident?
I've seen portions of it.
All right. And did I misstate anything that you saw on that video?
I don't believe so.
And by the way, Officer Lucky is still working with the Brooklyn Center Police Department, is that right?
Yes.
And he didn't receive any sanction or punishment for his conduct that day, did he?
Objection relevant.
The objection is overruled. You may answer.
No.
And what about Sergeant Johnson, the man that went in the car to try and stop Mr. Wright from leaving? He worked at the Brooklyn Center Police Department up until recently, correct?
Yes.
Was he ever sanctioned or punished or anything as a result of his conduct that day?
No.
And with respect to foot pursuits, that would be if you start chasing somebody out in the park, and if he's gaining ground on you, or if you're gaining ground on him, if it appears futile, you stop chasing him. Is that a fair statement?
Yes, that's one of the factors or those are some of the factors that would be
Yeah, and
considered.
it depends on what you're chasing him for. If you're chasing him for shooting somebody, you would chase him a little longer than you would if he had parked his car wrong, correct?
I'd like to think I would, yes.
Okay. And then we get to the use of force. You can use deadly force in your Brooklyn Center if force reasonably anticipated and intended to create a substantial likelihood of causing death or great bodily harm. Is that a fair statement? That's the...
I believe that's a fair definition according to our policy.
Okay. And that's the definition of deadly force.
According to our policy, yes.
That's what I'm talking about. And if someone hypothetically is inside a vehicle that's trying to take off, and part of his body's hung out and part of it's in the car, and the car took off, that person would be dragged down the road, correct?
Very likely, yes.
And that would cause great bodily harm, fair statement?
I would be concerned about that, yes.
Or if the car all of a sudden went in reverse and that body was hanging part on the car, it would also cause great bodily harm, correct? Was that speculation? I'm sorry.
The objection is overruled. You may answer.
You've experienced in your 21 years as a commander and as a police officer situations like that, haven't you?
Some.
Where officers were injured at the scene by somebody that
Yes.
they're trying to arrest?
Yes.
In fact, nowadays, isn't it true that the officers, and I believe I wrote it down here someplace, it's incredibly, this is how you described it, sir, in the beginning. It's incredibly more difficult and I throw in dangerous nowadays to be a police officer. Do you remember saying incredibly more difficult when you first testified? Here, did you say that? you can use force to effect an arrest too, correct? And that's in your policy.
Yes.
You can use force in effecting a lawful arrest, execution of a legal process, enforcing an order of the court, and a bench warrant is an order of the court, correct?
Yes.
And executing any other duty that may be imposed by you by your position, correct?
Correct.
And then there's another one, and the use of force to effective arrest in your policy, in preventing the escape or retake following the escape of a person lawfully held on a charge or conviction of a crime. You can do that too, correct?
Yes.
And if somebody's outside of a vehicle and there's a bench warrant for a weapons violation, and if he tries to flee, you can use force to stop him, correct? Reasonable force.
Yes.
And if he keeps resisting after using the physical force of pulling on him, getting him out of the car, you can also use other forces, like a taser, correct?
Yes.
If the car isn't moving. And if he still persists on it, after the man is warned that I'm going to use a taser, and he keeps fighting, and another officer is now in the car trying to stop him.
Objection.
I'm not done with my question.
The objection is overruled. You may finish.
And another officer is in the front seat laying over the passenger trying to stop this guy from going. And he is ignoring the warnings, taser, taser. I'm going to tase you. You have a right to use deadly force to save that cop, that police officer that's lying over the seat, correct? It's in
The
policy.
objection is overruled. You may answer.
Potentially, yes, but I wasn't there.
I know.
Yeah.
But if that fact scenario, yes. You've got to save that officer that's laying over the seat, correct?
Yes.
If you're dragged down the street by this driver, if he gets away, that man's going to be seriously injured or dead. Fair statement?
Could likely happen, yes.
And some of the factors in your policy, the immediacy and severity of the threat to officers or others. And if somebody's lying over that seat and another individual, an arrestee, is trying to get away driving and he ignores the taser,
Objection.
that would be the severity of the situation, would it not?
Ask that answer.
The objection is overruled. You may answer.
That would be, I'll rephrase it, that would be the immediacy and severity of the threat to the officers, would it not?
I think it would be severe and significant, yes.
And the conduct of the individual at the time of being confronted by the officers, that's another factor, is it not?
It's a factor, yes.
The effects of suspected drug or alcohol use, that's another factor, correct?
Yes.
If you go up to the car and, and you see marijuana shake or seedlings or whatever it is, and you smell marijuana, that would be an indication from an experienced officer like yourself, there may be marijuana in that car, correct?
Good, yes.
Or maybe the fellow driving the car is using marijuana, correct?
Possibly, yes.
And when the individual doesn't comply with your demands, you have to escalate the force that you use, correct?
Sometimes, yes.
And when you go up to that car and you know it's a weapons bench warrant, where this man has been charged, although it's a gross misdemeanor, with having a weapon on his person or in his constructive possession without a permit, correct?
That's a mistake.
Well, the objection is overruled. You may answer if you can.
You want me to rephrase it?
I would be extremely concerned
Okay.
if I was going to arrest someone that had an arrest warrant for some sort of weapons violation.
In the policy with respect to moving vehicles, that's talking about vehicles moving. It's not talking about a vehicle stopped, correct?
I think that policy on vehicle pursuits talks about vehicles moving or potentially initiating a vehicle pursuit. Or are you talking about the shooting at or from a moving vehicle?
Yes.
The shooting at or from a moving vehicle, I believe, is focused on a vehicle in motion.
But if, okay. How would you describe Kim Potter as a police officer in Brooklyn Center from the 20 years that you worked with her and you were her commander?
Objections.
The objection is overruled. You may answer.
She's a good cop. She's a good person. She's a friend. I had no concerns going to calls with her. I had no concerns with her.
And now we're
You're interrupting.
inside the proper bounds of.
Okay, let's sidebar, please. The objection is sustained. Don't answer that, please.
Previous portion of the answer be stricken with jury selection.
Your Honor, you said that.
I'll let the answer stand. The reason for me sustaining the objection is beyond the scope of the direct.
Did you, on the date of this incident, did you and the police chief Gannon go over to Kimberly Potter's home?
Yes.
Objection scope.
I don't know where you're going. I'll let you said yes, I'll let the answer stand.
Why did you go there?
Objection scope, Your Honor.
The objection is overruled. You may answer that.
We have been told she had hurt herself.
You mean self-hurt?
Okay, the objection is sustained now. And the jury is to disregard that last question and answer.
May I confer with Mr. Engen? I think I'm done. Thank you, Commander. I'm done.
Mr. Frank? Mr. Frank, I think we're going to take a lunch break, unless it's going to be like 5 minutes.
I would think so, Your Honor.
Okay. All right, members of the jury, we're going to take our lunch break.
I thought it would be quicker, Your Honor.
Oh, you said it would take 5 minutes?
Yeah, that's not quick enough.
Okay, sure.
Sorry, go ahead.
Sure.
Trying to be thoughtful of the officer's time as well. You were asked, Commander Flesland, about the use of force and things to consider. I won't be quite as demonstrative, but does the law and your policy also require that officers take into consideration the potential injury to officers, suspects, and others through their use of force?
Yes, that should be a factor that's considered.
Do they also have to consider collateral injury, injuries to others by their use of force?
Yes.
Do they also have to consider less force, if they can?
If they can and it's reasonable.
You were asked about people who are fleeing, and it was represented to you that, how would you think about that if they weren't fully identified? Should an officer take into consideration when deciding how to handle a fleeing person if they have been fully identified?
That could be a factor.
I object unless is he talking about somebody?
Okay, no talking objections.
I'll withdraw the objection.
Oh.
I can't remember if you answered the question here fully.
Could you restate the question,
Sure.
please?
In deciding the amount of force to use, you were asked a lot about a person who was fleeing. And is one thing an officer should consider is whether they have already fully identified that person.
That should be one of the factors considered.
And are officers then, in exercising force, whether it be deadly force, are they required to use no more force than necessary?
They should use no more than is reasonably necessary to accomplish the task.
You were asked several times, in very dramatic ways, about how an officer should act when people are hanging out of the car. Remember some of those examples?
Yes.
Were your answers to those questions based entirely on the representations from counsel about the fact scenario of those questions?
Excuse me, I place an objection.
Ruled.
So, you recall the question.
If you could state it one more time, please.
You were asked on many occasions about various factual scenarios and how you would react to those and perceive the use of force in those. Mr. Gray made representations to you about the situation and asked your opinion. Do you recall all of that?
Yes.
Were your answers based entirely on what Mr. Gray was representing to you as the facts to consider?
No, I included other thoughts I guess I had.
About what? I mean, what other thoughts?
Other situations I may have been involved in, may have witnessed.
Sure, in deciding how you would act or what you might do. But I'm saying all of the facts of that incident, Mr. Gray gave to you, correct?
I was trying my best to answer based on the facts that he had said.
Regarding this incident involving Ms. Potter, did you interview any witnesses?
No.
Did you watch all of the body camera or dash camera video?
No.
Have you reviewed any of the reports regarding the case?
No.
In the answers that you were giving to Mr. Gray, are you basing those answers at all on what happened with Ms. Potter and Daunte Wright on April 11th?
I'm sure I'm thinking of the small portions of the video that I've seen and relying on Mr. Gray laying out a set of possible events.
But do you know if any of those events occurred?
They seem to be in line with the portions of the videos that I saw, but I am by no means an expert on what happened that day.
Well, you said you didn't watch all the videos.
No.
You haven't interviewed the people involved.
No.
And so you're allowing, when you're answering these questions, are you answering them based on the additional drama that Mr. Gray has added to the situation?
Object to that is asked and answered in meeting, and asked her to not mention drama again.
Okay, yes. The objection is sustained as to using trauma.
All right. I'm sorry about that. Let me ask it this way. Are you offering an opinion on Kim Potter's use of force that day?
No.
Your answers to Mr. Gray, you've been telling us you had this video in your mind, not based on, are your answers to Mr. Gray's questions not based on what actually happened out there, but what little bits you saw plus what Mr. Gray added for you?
I was trying my best to answer them based on what Mr. Gray was explaining the events that he articulated.
You indicated that training is not real life, correct?
It's never exactly like real life.
Is part of the training trying to teach officers to think in stressful situations in real life?
Yes, we strive to try and really encourage critical thinking. We try and make training as realistic as we can, but we acknowledge we can't make training exactly like real life.
And would a good police officer try to make good decisions under pressure?
Object to that is leading, Your Honor. Also, opinion of the witness.
The objection is overruled. You may answer.
I expect good officers to make good decisions.
You were asked about moving vehicles. And does an officer have to take into consideration whether a vehicle that's sitting still could be put in motion when they're deciding whether to use force and what level of force?
It should be a factor considered.
That's all I have, Your Honor.
I have just a couple of questions. Good afternoon, Commander. You did see parts of the video of the traffic stop in this case, correct?
I've seen parts.
Okay. And you did say that good officers make good decisions, correct? You just testified to that?
My hope is good officers make good decisions, yes.
And you did describe Kimberly Potter as a good officer, correct?
I did.
I have no further questions.
Anything further? Please step down. Okay, members of the jury, we are going to start. It's like what is it now? It's almost quarter to one. We'll start at 1:45. Okay, so you get a full hour for lunch. Okay, have a good lunch. Is that all?